You know, law is a business, but the most important thing we always have to remember, it is a profession first. And that's hard, especially when we have to talk to our partners about those issues sometimes. Always ask yourself throughout today's panel, what is the biggest issue that I'm facing? Is there something some duty that I owe my insured or my client? And whose interest comes first, their interest or my interest? Because at the end of the day, if you put yourself first, which is our culture today, right? It's me first, what's in it for me? That's gonna get you in trouble. And today we're here to talk about a lot of these issues, how it affects the public, how it affects your client. With that being said, we have action-packed panelists today.
Please stop saying that.
We're going to start doing calisthenics first. We have our prime moderator, Michael Packer. Mike, I was going to let you maybe introduce yourself, introduce the panel.
Okay. My name is Michael Packer. I am a shareholder at Marshall Dennehy, Warner, Coleman, and Godkin, where I am in charge of our Florida coverage and bad faith practice group, where I exclusively represent insurance companies in either coverage actions or bad faith matters throughout the state. To my right is Ninoshka Meir.
I'm Ninoshka Meir. I'm shareholder at Robinson.
A legal malpractice insurance company that was started by the Florida Bar approximately 30 years ago, and I too am very glad to be here.
Excellent. If anyone has questions during the presentation, please feel free to raise your hand. A lot of times I try to stump the chumps, so we have a lot of people here who are anxious to answer your questions. Mike?
And in case you couldn't already figure it out, we're going to be talking about insurance, legal malpractice issues as it pertains to defending civil litigation that insurance companies are involved in. And as you can also tell, we have a pretty diverse panel, even though we're all essentially on the same side. Ninoshka and I are outside counsel. I represent the insurance companies directly. Ninoshka represents the insureds. Jason Weissman essentially is an employee of an insurance company, but at the same time represents insureds. And then Jason is an in-house counsel representing the insurance company from within the company. Just by a show of hands, how many people in the room are hired by insurance companies to represent insureds? All right, so we have a good amount, and as those know, and as hopefully the others in the room will get an idea, the process in which attorneys represent insureds who are sued in civil litigation creates a very unique relationship, because you have an insurance company hiring an attorney to represent another person or entity. The insurance company is paying the bills and directing the litigation, and so it creates a extremely unique in the legal process relationship known as a tripartite relationship. This relationship is so with an insured, and you are their attorney. And Ninoshka, I'm sure you deal with this in every case that you have. How do you go about creating that rapport, getting that comfort level with your client when they had no involvement in selecting you and they don't know you?
Yeah, it's constant. And for those of you, I see many of you who do represent insureds, you're their attorney, right? And I call them, and many times my interaction, their initial one is over the phone. So I have to know me, you didn't select me, you don't know the first thing about me, I'm your attorney. And then I express to them, the statement of client's rights is kind of like where I come in peace. Here are your rights. Here are my obligations to you. I'm here as your servant, if you will, as your defense counsel. And then I explain, yes, my fees and costs are paid for by your insurance company, because somewhere in all that gobbledygook of that policy that's 40 pages long and 8-point font, it says somewhere in there, we have the right to retain an attorney for you. And that's where the insurance carrier is exercising that right. Well, the portion the insured is entitled to is basically, as we know, taking that measure to protect themselves by putting that layer of defense for the insured. And then I always explain, I go basically, my major points are everything we discuss is privileged and confidential. Now, we know we report to the insurance companies, right? We have to report to them as far as what's going on status. However, we cannot say anything that will basically hurt or revoke their coverage. In other words, if there's anything that will trigger a reservation of rights, or the insurance carrier is going to think twice about providing coverage for that particular incident, we can't disclose that. If we have a conflict, then we have to step out and step aside, and that's all there is to it. Otherwise, we are reporting to the insurance carrier, and that's what I explain to the clients. But my obligations are to the client. I keep the client, obviously, to keep them abreast of everything that's going on, informed. And while I say, listen, you might not like that the insurance carrier paid your limits. I get it. The other person did everything wrong. You did nothing wrong. However, the insurance company has that right to exercise that choice because they think they're acting in your best interest. And so I'm here to basically guide the way for you to recommend the best decisions. Well, I'm going to make recommendations for you, but I always make sure my client knows they're at the wheel. They literally have the decision-making power. And I'm there just to give my recommendation. And certainly telling them part of the statement of client's rights, they have the right to choose their own attorney. Many times they have a family friend or a relative that's an attorney or does real estate, and we're going to help them and give them no problem. Whatever it takes for the client to feel comfortable and fully informed.
Can I jump in here? You know, I would hope that the carrier hasn't set up counsel to have to make that call cold. I'm your attorney, you never heard about me or anything. The carrier's job is to explain this up front as well. And obviously, we're usually the first contact that the insured has when they report a claim. And we should be doing our job and explaining to them all those things that she just said, and then doing the commercial as well, and explaining that, look, we pick good counsel because our interests are aligned with yours. Our interests are getting this claim resolved for as little money as possible and getting you out of harm's way. And so certainly I don't pick counsel that work for us who don't do that. And what I tell our insureds all the time is, if you have a problem with them at any point, call us and let us know. And I said, you know, and I'm very frank and we're very upfront about these things. What I tell them is, it's been very rare in my career. I've been working for insurance companies for 15 years where I've had to switch counsel. I mean, there might be a conflict, there might be some sort of a disagreement. Usually we can work it out. But if you have a real issue, you call me and I'll get you new counsel. And that goes a long way to breaking the ice on that first call and getting you in the door so you can talk to them and explain, and then they get to see that you do know what you're doing.
So that's an excellent point, if I could just throw in something. Sometimes, have you guys experienced assuming that Jason even does that, some carriers don't do that, which is surprising. But do you ever have the experience where you have to convince the insured that you're an outside lawyer? Because from their perspective, what do they think?
Oh, they automatically presume I'm representing the insurance company.
Right.
And so I bring them right back and I said, let me be very clear when I say I'm your attorney, I am your attorney. And then I always direct them to the adjuster, talk to the adjuster. The adjuster many times does give them that roadmap, but many times they haven't been able to reach the insured. And so I reach them for the first time with an investigator. And even if and sometimes there's a language barrier. But yeah, for the most part, our adjusters do a great job, and really it's just kind of keeping everyone, or the insured informed that I am their advocate solely for them.
And Jason Weissman, how do you deal with this circumstance? Because Minoshka at least has the ability to fall back on the fact that she is outside counsel, she's with a private law firm.
But when you're meeting your insured or speaking to your insured for the first time, and your business card has an insurance company on it, so how do you go about in your practice explaining and building that relationship with an insured when you in fact work with the insurance company?
So one of the good things about working in-house staff counsel is that claims already lost me and my people. So I'm not fighting a battle as far as them trying to promote us to the insureds. Part of the problem that we're going to run into is that we're employees of the company that's insuring the loss. So right away, outside counsel runs into the problem of, oh, you guys are just beholden to the insurance company. Oh, we're actually employees of the insurance company. So, that's going to be the first thing. And we have to let them know. There's actually a Florida bar rule, I'm sure. Maybe some of you have seen it, 4-7.21. It talks about how we have to disclose that we're employees of an insurance company, that there's got to be a lawyer's name just to show that there's a lawyer supervising the outfits. You don't have a non-lawyer in charge of the operation. But, we go an extra step. It's not even really required, at least in Florida, to get informed consent, where we get them to sign not just the statement of client's rights, but we have a phone call. We say, this is who we are, this is what we're going to do. Are you okay with us being your counsel? Quite honestly, I don't think that's ever happened where we've had a problem, unless it was a company that had some long-term relationship with a law firm prior to us insuring them. And they'll sign it, and we're good to go. But we always have to approach it in the same issues that Mike and Anoshka have, as the insureds are our clients. And while we are employees of the company, that we're the insurance company, we still, our main duty is to the clients, to the point of we can't take action that's going to invalidate coverage. We can't narc on our clients saying they're doing X, Y, and Z wrong, and you need to know about this claims. We have to still be totally loyal and hold certain confidences with the insureds, to the point of we may have to withdraw if it gets to a point where we think the insured is doing something wrong, but we can't let claims know what that is. So we run into a lot of the same problems. I think the biggest issue always for us is looking and making sure to avoid any kind of coverage situations. So, or if there's an excess policy or judgment potential, we can't keep those either, because it's bad enough when outside counsel doesn't identify those issues, but at least they were outside counsel. It looks worse when you have an employee of an insurance company, maybe even if they weren't doing anything wrong. The perception is maybe they only cared about the carrier and put their insured in a bad position and open to an excess judgment.
One of the areas that can drive a wedge between a client and their attorney who was hired by the insurance company is the fees. Nunoshka mentioned that more often than not, the insurance company is going to be covering those fees, but there are going to be circumstances where an insured may be responsible for some portion of the fees, whether it's a deductible, whether it's an SIR, a self-insured retention, or whether or not there are claims that are involved in. Also, and Nunoshka you touched on this a little bit, but part of the representation of an insured pursuant to an insurance policy is that the insurance company is going to be acting at the direction, more often than not, of the insurance company. But at the same time, the lawyer cannot act solely at the instructions of the insurance company that is contrary to the interest of the insured. How do you go about those circumstances when you might be getting a directive from the insurance company that you feel may be contrary to the best interest of your client?
I don't know that I've had many instances where I get a contrary directive from the insurance company to the insured. What I find myself more is when I think the insurance company needs to pull the trigger, if you will, as far as tendering quicker, when there is for me, a fatality, a lost limb, catastrophic loss, someone in a coma for, anything, in a coma, whether it's a day or 30 days, it's terrible. All those types of things that just jump out for me are red flags where I want to urge the insurance company to tender so my client is not exposed to a lawsuit. That being said, it's that balancing of, you know, I don't want to question their evaluation, so I have to be very delicate in when I'm still representing. There's some finesse, I guess, when you're like, please make sure you're protecting the insured. And trying to, even speaking to my adjuster, sometimes I just have frank conversations with them on the phone before I put anything in writing, because I don't want to betray that either, but I'm telling them you need to do the following, and I have to put something in writing. I want to let you know. And the other part of that is when they're making a counteroffer as opposed to tendering on one of those knee-jerk reaction cases. Sometimes they're paying half of what is available. All I'll just say maybe in the letter is please protect them up to their insurance, their limits, their coverage that they've purchased with the insurance company.
I think you've said something incredibly important, which is call the carrier first. Do not surprise a carrier with something in writing that they're not expecting. And that's just a practical business tip. It goes a long way, because you will come across information at some point in a case that is detrimental to the carrier's position one way or another, or requires a change in their strategy. And you know, as an experienced adjuster will tell you that we've all had that happen. That's not unusual. But you better prep them, because if you know anything about the insurance business, you know that there are layers beyond that person that go up very, very high. And so the things that they have to do to get things lined up and in order might take a little while. And so all I can stress is just for your own business continuity, give that carrier a call first, give them a heads up, and you can even tell them, look, I've got to put this in writing. I mean, it's my duty to the client, and frankly, I got to protect myself as well. You're doing your job. We understand that, but give us a heads up so we can kind of get ahead of it.
Right, no
Question?
surprises.
Right. You remember that.
I have a question. You were talking about wedges between the insured and counsel and the insurance company. And one of those I find is the reservation of rights letter. When the insured gets his letter saying, listen, we're gonna pay for your lawyer, we're gonna select the lawyer, we're gonna direct the litigation, but if we lose, we're not gonna pay. Right? That's how the insureds interpret those reservation of rights letter. How do we handle that vis-a-vis the insured's desire to select their own counsel, but they don't wanna pay out of their pocket?
I can
Great
tell you.
question.
I can tell you what we do is we alert them of the reservation of right, and I ask them if they still want us to represent them. We prepare a very short form and we have them sign off, granting us permission to continue representing them and they're aware of what comes with the reservation of rights. And that's how we document our file, that there's notice, there's knowledge, and there's acceptance of it, and we're going to proceed with defense.
One of the things that we would also do at some of the carriers that I've worked for is in those situations, what we tell the insured is, you're welcome to retain your own counsel at your own expense to shadow everything we do. And if you want to have personal counsel involved at your own expense, that's okay. And I would say more than half the time, they might do that initially, but then as things go down the road, they get tired of paying that bill when they see that counsel that we hired is competent and is doing what they need to do. But you're right, usually that's the first call we get.
And
As a follow-up to that, real quick, on that particular issue, isn't there, and I can't remember it, but isn't there a provision that says that if under a reservation of rights situation, if they want to select their own counsel, the policy has to pay for it?
I was
no.
gonna let Mike summarize.
Right, yeah. Let me.
What we're talking about is the claims administration statute.
And 2 points. One, representing the insurance company, when the insurance company is going to defend an insured under a reservation of rights, that is communicated, obviously going to be communicated in writing in the reservation of rights. But what insurance companies should also, or typically do, is they explain it to the insured, and they have the insured acknowledge that the insurance company is retaining this counsel on their behalf, and that they accept them. Now, it's going to be incumbent upon defense counsel hired by the insurance company to sort of have that rapport with the insured so that they have that comfort level that they're going to represent their interests. As it pertains to your second question, under Florida law, the insurance company is not required to pay for personal counsel or counsel at the insured's selection as it relates to a lot of other states known as CUMIS counsel. Florida does not follow that. Rather, the insurance company's obligation is merely to provide mutually agreeable counsel under the Florida Claims Administration Act. The way that we do that, or way insurance companies do that, is have the insured acknowledge that the attorney being hired is mutually agreeable. Now, can be a conflict there, and that's where negotiations come into play, where the insured says, I don't want your attorney, I want my attorney, and then there has to be some sort of give and take between the insurance company and the insured, whether it means finding a different attorney that both sides can agree on, whether or not there's some type of vetting by the insurance company of the counsel the insured wants to hire. They feel comfortable that they meet their qualifications and they're willing to accept the rate that the insurance company is willing to pay, or the insured's going to pay a portion and the carrier's going to pay a portion. It's always better to have that give and take between the insurance company and the insured, so that it prevents the conflict further down the line. But Florida does look at that issue differently than some states. You have cumulus counsel, and then there's also a number of other states that have a third category, and I'm drawing a blank on it. It's sort of a hybrid between cumulus and mutually agreeable.
Yeah, there are some states where if you simply say reservation, the insured's entitled to independent counsel,
It's a
but
black
not
and
Florida.
white rule.
Right, but not in Florida.
Not in Florida, but usually what we're saying is, and I guess to summarize, which is an excellent point, which we see a lot, right, because maybe some distrust between the insured and the insurance company, or, maybe there's only one covered count out of 12 counts. And your concern as an insured is, well, I might get tagged on these other counts, and the insurance company's not gonna be there to pay the judgment. I want my own lawyer, where I feel like that might happen sooner rather than later, where coverage might be summary judgment on the covered count. What happens in that point where I want my lawyer? So what Jason has said was, well, maybe you want your personal counsel, or there's a compromise. But one of the things, I guess, that comes out of this, where Nenosha said, not to monopolize your time, is when do you feel that it's appropriate to maybe meet the insured?
I take every opportunity to meet the insured, and personally. I always prefer a personal meeting, whether it's in my office or I'll go to a location closest to them. My practice has become where my insureds now are all over the state. So it's just not as feasible all the time. Otherwise, yes, I always welcome them for a personal meeting, and that's always much better.
It really does depend. It really does depend on the kind of insurance we're talking about. If you're a large auto carrier, that may not be practical. I mean, just to be honest about it. But as a legal malpractice carrier, if you're doing professional liability, it's a little bit more practical because our claim volume tends to be lower. And my rule when I was running a claim department was I wanted a partner going out and meeting with our insureds immediately. I mean, within a week of getting the case. Because, as you said, that's the thing that goes the furthest in smoothing everything out. When they can sit down across from you and realize, okay, you know what you're talking about, you've done this before, that takes care of about 90% of those initial problems. But if you were running a large state auto program or something like that, you're probably not going to be able to meet with all your insurance.
I mean, just along those lines, I don't necessarily have the same legal malpractice concern. I mean, I don't want to commit legal malpractice, but I mean, it's a little different. The chances of us getting accused are a lot slimmer. But what Nanoshka's saying, I think, goes a long way to, if you get to know your insureds, the problem is that most insureds feel like they're just a number in a business. And you don't really care about them. You're only there because of the insurance company. But if you're going out and meeting with them, talking to them, making it really seem like you care about their concerns, most of these people, well, depending on what kind of work you have, but a lot of these people have never been in a lawsuit before, so it's very stressful for them. Most people, when they like you, even if a case goes south, they don't want to sue you. Okay, so if you can get out there and actually get a relationship with them, they will tell you even when things go bad. Well, it's a shame it went that way, but I know you did a really good job for me, and I really appreciate everything you did. And it kind of keeps you out of harm's way. And there is a tendency, I know, I've been there, of people feeling like the insureds are kind of more the problem, and you just want to deal with the carrier. That's my real client. That's not going to get you real far in life. as far as staying out of harm's way with legal malpractice. So just it really makes a big difference to get to know your insureds,
And
put
let me-
them at ease.
And let me just say this again, this kind of goes back to the business side of things. One of the things that I always told our counsel that worked for us was, you're probably the first person they've dealt with face-to-face with regards to my company. They don't meet their underwriter. They don't meet the claims person. They have had a policy in a drawer for 12 years, and this is the first time something's happened. So I look at it as, you're the representative of my company going out there and helping me keep a customer. And therefore, if you go out there and you don't do the things that Jason just mentioned, if you don't make them feel at ease, not only am I going to have a difficult claim to handle, but I'm probably going to lose a customer as well. And so I always encourage people who do defense work to really get a kind of an understanding about how the insurance business works. And the better you understand it, the better you can understand why we ask you to do the things we do and why the things we ask you to do are important to us.
Right, and that kind of gets away somewhat from the ethics malpractice part of it, but it is extremely important. If you want repeat business and you want your carrier to be healthy, make their insureds happy so that they keep coming back.
Sir, did you have a question?
Oh, actually, I had a question just to clarify. When you mentioned communication, call the carrier, are you directing that to attorneys that are working for the carrier to represent insureds? Are you what's the scope of that? Call the carrier.
I was talking about when we've hired you as outside panel counsel to defend an insured, and you come across a situation that is going to change something significantly, whether it's a potential coverage issue, an excess situation, whatever it might be. As Rory said, because I've been saying this for 15 years, the one thing insurance companies can't handle are surprises. And it has to go, there's a very practical reason, and I don't want to get too far off topic, but, we set our reserves based on the information that we get from you as you're handling the case. And obviously we have some of our own thoughts about it as well. Those reserves have an impact in how we price our product. So if a case is going on for 3 years and we've had a low reserve, my actuaries have looked at that and said, okay, we think this is going to develop about another 1.5 times, so therefore you can charge X, Y, and Z. 5 years later, it becomes a multi-million-dollar claim. Not only did I underprice for all those years and I can't get that money back, but now I've got an actuary who goes, you know what, I might have to start increasing all my projections, which means my prices are now going to go up, which means I'm now not competitive in the market, all because we were behind the ball on this. So those types of pieces of information, those types of situations, call the insurance companies so that we can prepare for what's coming.
Sir?
Question.
The other thing is it's a two-way street. You're evaluating the insured as well.
Right.
You conduct in the initial conference sort of a friendly deposition, because you want to see what kind of appearance that person's going to make down the road when they take the stand. That's part of your evaluation that you give to both the insurance carrier and the insured.
Right.
Very good point. So you're saying credibility also when you're the lawyer meeting the insured of a client.
Yeah, if I go to somebody's office, I represent lawyers, I go to somebody's office, they can't find half the file. They're
Yeah.
taking half an hour to tell me where something is. That gives me an impression, and it becomes important later on.
In other words, they might not appear well at trial, they can't find their own file.
That's true.
Thanks. For any attorney who gets hired by insurance companies, probably the bane of your existence is litigation guidelines and the guidelines that insurance companies place on their defense counsel that essentially direct everything that the defense attorney is going to do. When you're representing an insured, it is imperative that you explain those guidelines to the client so that they understand that why you're doing things in a certain way. And likewise, if you believe as the attorney that you've been denied authorization, because let's face it, a lot of these litigation guidelines, you are required to get authorization from the insurance company before you take on certain tasks, whether it's dispositive motions, hiring experts, taking depositions, all of these things that in other areas of the law you take for granted. If you're representing a client, you believe you have to do something, you go and do it. But when you're representing insureds and your bills are being paid by an insurance company, you have to go and get authority to do certain tasks. So you know, and I throw this out to the panel, how do you deal with it when you believe that you need to take some type of action in the best interest of the defense of the case or in the best interest of your client, and you're either getting pushback from the insurance company in regards to your request, or they flat out deny that request?
I document my file. I document and document. And like I said, I use the power of the phone to get my adjuster and get their ear to explain my situation and why we need it. And then I get to have some more candid conversation from the adjuster. And then I document my file accordingly. And whether it means I'm requesting this, I understand for the following reasons, maybe we can't, but that is key because I know, and I've learned a long time ago, your file is your diary, it's everything. So I know that if I'm ever questioned, it's all documented.
You know, I think there's a tendency, especially if you've been practicing for a while and you're kind of taught to handle files a certain way, to just do things rote on every file, and that's part of the problem. If you write summaries of information, reports to the carrier that are useful and not just because it was a 90-day report, actually has a value add, and you can say, I need this expert and this is what value it's going to bring to the case, and I need it specifically for this reason, and it's going to affect the value potentially in this way, you generally don't get a ton of pushback. I mean, I can't say that'll never happen, but it's when you just kind of ask, well, it's a back case, I need a records review and a CME, and you didn't. It just, a lot of people have this bad tendency just to do certain steps on every case, and it's not always warranted. Where if you can explain specifically why you need those things, and again, the value add is the big part of that, and how's it going to change the evaluation ultimately. I haven't really had that problem if we present it that way rather than just saying, well, we need this because we're going to mediation.
Super important, just heightened communication.
Right.
And Jason, at the end, have you ever, being inside, have you ever been made aware of a situation where you had a defense counsel who wanted to take certain actions in defense of a case, and one of your claim professionals, for whatever reason, was not authorizing it?
Very rarely, but yes, and it tends to, my experience has been it doesn't necessarily come up with, we want to retain an expert. It tends to fall more in the, we're going to bring summary judgment. And, when I was at my old company and even now at Florida Lawyers, I had mainly attorneys handling our claims and mainly attorneys who had practiced before. And these are people that understand, there's a good time to bring a summary judgment motion. There might not be a really good time to do it. And then there might be cases where the facts just show this is not a summary judgment case. So there have been times when we have said, no, we don't think we want to bring a summary judgment at this point, especially if it's going to preclude you from bringing it again later on. Sometimes you want, everyone in this room knows, sometimes you bring them for strategic reasons, to put a little pressure, maybe to force people to the table, whatever it might be. But in those cases where outside counsel couldn't convince us why they wanted to do this summary judgment motion, what they were going to get out of it that was going to make us better, we did say no.
Right, that's more of a gray area trial
Right.
tactic.
Absolutely.
Situation.
But when it comes to
retaining an expert.
retaining an expert, I'll be frank, you can really be, a carrier can set themselves up if you say no to every request that comes in for how to defend this case, and we're aware of that as well. If you call me up and say, hey, I want to hire 6 experts, we're going to have a problem. But I'm actually I kind of fall into the school of, I've even gone so far as to say we hire experts before litigation's begun, because maybe it tells me something I need to know. And often it's usually something I don't want to hear, but at least now I'm prepared. But it's pretty rare that we say no to things like experts, taking an extra deposition, things like that. No.
Timing is key.
Absolutely.
Case.
Well, yeah, and it all depends on what kind of work you're doing too. I think what you're talking about, you have lawyers as claim handlers because of this, it's more sophisticated work,
Right.
If you're doing auto and general liability, it's probably not going to be an issue. So they're going to be looking to you. I've found that most claim handlers, when I worked at Fowler White and working now, they're looking to the attorney for information. They're not trying to stonewall you from every opportunity to defend a case. But they're looking for expertise and not wishy-washy guidance. And when they think you're just doing things for the sake of doing them, that's where you run into problems. If you can't tell them why, specifically why you're doing it, then you're gonna get rejected on those requests.
But should you find yourself in that circumstance, you have to let the client know. And the question I would have for our panelists, as well as anyone else in the room that gets hired by insurance companies to represent insureds, have you ever had to have that conversation with a client where you had to advise them that there was some type of strategy, something you wanted to do in defense of the case, and for whatever reason the insurance company rejected that request?
No.
I've had it come up more often when the client has the friend or family member who's a lawyer behind the scenes telling them, you can do this, we should have won on a motion to dismiss.
Right.
And again, you deal with that, and you do explain to the insured why you're doing.
Sure.
Yeah, absolutely. We all love to sit back and look back and go, oh, we should have done this, should have done that. But that's really where it comes into play more than just about anything. And, what I always kind of fall back on with my insureds, if it comes to this, is I said, look, our interests are aligned. I want this case resolved, and I'm not in the business of paying more money than a case is worth. So, let us try this, and if it doesn't work, it's actually going to be on us. But again, it's a pretty rare situation.
The circumstance where I have experienced it has been where the client, the insured, either wanted to file a counterclaim against the plaintiff,
Yeah.
or if it's there are multiple defendants, wanted to file cross claims against one of the defendants, and really whatever the counter or cross claim was outside the purview of defense of the case. And that's one of the things when you're meeting with a client, meeting with an insured for the first time, it's important that you explain your role, and the reason you're being hired by the insurance company is to defend the lawsuit that's getting filed, not to file cross claims, counter claims, etc. Now, if they advance the defense of the case, that's one thing, but it's important, as we've really been talking about throughout our discussion today, is the communication. And if that comes up, and it has come up multiple times with me in the past, where I had a client that wanted to file a countersuit, wanted to file a cross claim, and I said, doing my representing an insured, I went to the carrier and said, hey, they want to file a cross claim, they want to file a counter claim. What are your thoughts on this? And from time to time, the response has been, yeah, that's going to help the defense, so go ahead. Other times it's been, we don't believe that has anything to do with the defense. They're welcome to do it. They're going to either have to pay you separately, or they're going to have to find another attorney to do that. And you need to have that conversation. It should be upfront, as well as when the issue raises its head, that's not your role in the case. Your role is to defend them, and if they want to pursue a claim, that's something they have to.
And the biggest issue with that, and we've done that many times where we think it helps us, but the conversation then that I have to have with my insured, and that we do put in writing, is a couple things. Number one, once we end our side of this case, if your counterclaim is still out there, we're not going to keep paying to go forward, so you're going to have to step in and do it. And number two, don't let that counterclaim be the impediment to resolving this larger issue. And again, you have to tell them up front that that's how it's going to go down, and we remind them in writing, and then when you get to that point, they're prepared.
That's an excellent point. So in summary, it's really the scope of
Right.
representation, and sort of another issue that comes out of that is sometimes insurers want to use the defense counsel or the insurance company to fund
Right.
offensive litigation or experts for other counts that might not be covered.
Mhm.
And that triggers other issues. In terms
And-
of communication, and so how would you guys handle it?
And you bring up an excellent point, Rory. What about the scenario where it's a multi-count complaint, some of which are covered and some of which are not covered? Well, under Florida law, the insurance company has to defend the entire lawsuit,
Right.
which is going to mean in those circumstances, if there are counts that aren't covered and those counts require strategy, defense cost experts, the insurance company needs to authorize those expenditures, and it's incumbent upon the attorney to treat those counts, which it may, and defense counsel is not really supposed to know that, or that there may be counts, or that counts are not covered. But let's face it, hopefully, if Nenosha is representing you, she's smart enough, she's knowledgeable enough, she knows if there's a count in that complaint that is not gonna be covered.
Jason, how do you see that in the crosshairs of the
Yeah, I mean, if you're a panel firm attorney, this is where you make your bread and butter, because I can't take those cases. So it's a good news story for law firms in the state, because we can't handle those.
When you have a situation where you are going to be working for the client, for the insured directly, and a compulsory counterclaim that the insurance company says is not part of the coverage, are you allowed to charge the insured a reasonable fee, or are you supposed to charge what the insurance company says that you're supposed to charge?
Good question.
Absent, and again, this is based purely on my experience, absent the insurance company having some sort of guideline or position on that, it is a reasonable fee, because you have to appreciate the fact that when you're a defense counsel representing insureds at the retention of the insurance company, you're not, we're not getting paid what I would consider necessarily the reasonable market fee, or the
I would
rate that I
disagree.
see, or the industry rate that I see policyholders, for instance, getting paid. And part of the reason for that is because you're getting, you accept a lower rate because your expectation is you're getting a quantity of work, you're getting a large amount of work as opposed to an individual situation. And you're hoping, that the insurance company, assuming that it is, it is an established company, you're never going to have to chase down your fees, which we all know may not be necessarily the
Meaning
case.
they'll pay your bill.
Right, exactly. As opposed to if you're taking on an insured to file a counterclaim, there are inherent risks with that, getting your bills paid. You're most likely never going to have that person or entity again as a client. So you are, you have the right to charge them what you consider to be a reasonable fee. I don't know if anyone disagrees or has a different view on that. Jason, I mean, from the insurance company's perspective, if you found yourself in that circumstances, and you don't have to limit it to your company, are you aware of companies having insurance companies having a position in that regard?
Not really. I mean, there's usually nothing that's a policy. I will say this, one of the key differences that we really hadn't touched on, and it's an important one for this conversation, it really depends also, is the defense coming out of the limit of liability or not? So in other words, if you've got a lot of auto policies, the defense doesn't come off the limit that's available to pay the settlement or judgment, so these issues don't come up as much. But if every dollar that I spend defending or prosecuting a claim that's contained within that case comes off of the limit, then there's a real issue. And so we also have to have that conversation with our insured too, that look, you need to preserve some of these dollars. You don't want to go nuts and have us fund all that.
And Jason, you bring up an excellent point, and I'm gonna ask you, for all of the folks in the room who don't represent insureds hired by insurance companies, maybe you could explain to everybody exactly what you're referring to as far as wasting limits and fees coming out of the limits.
Professional liability.
Right. Most professional liability policies are considered wasting limits, and that means you have $1 million. I'm just going to use an example. You have $1 million limit of liability. That's what is on the declaration page. That's how much coverage you have. If it's a wasting limit, every dollar that gets paid for defense gets taken off that $1 million. So if you spend $500,000 defending, you have $500,000 left for a settlement or a judgment. Other policies, and the auto world is the most common, but you will see some professional liability policy where you can pay extra to get what I'm going to talk about. You can have covered, you can have defense outside the limit, which is a separate limit. Usually those have a finite amount of money as well, though. So maybe you have $1 million worth of defense cost and then $1 million worth of indemnity. And every carrier is a little bit different in how they do it, but for the most part what happens is if you exhaust that $1 million defending, then the next dollar comes off the limit of liability, but it gives you an extra cushion. But when you're dealing with a lower limit situation, if you've got a $250,000 policy and you're dealing with a multi-million-dollar piece of litigation, you don't want to spend many dollars defending the case. You want to spend those dollars resolving it.
And Nenosha, how do you deal with that when you're meeting with your insured, you're having that conversation, and you have to let them know the work that you do may impact not their coverage limit and potential personal exposure?
Well, yeah, we always have to have that initial conversation, and I see a question, but real quick, that's the initial conversation as far as their, all our fees are covered, but yeah, they're only covered up to their limits, and that's where we discuss what is a protected asset versus a unprotected asset if my particular client is gonna be personally sued and what he or she could be facing. You had a question, sir?
Yeah, well, it's an interesting conflict for defense counsel in that situation, because with a burning candle or diminishing limits policy, every time I write a letter, I'm diminishing the limit.
Mhm.
Am I helping my insured, am I not helping
Right.
my insured? And if the limits are small or smaller and the claim is larger, it becomes a real factor, especially as we go along and no one's settled. And here you are a year into it. What do you do now when it comes to taking that extra deposition?
It actually goes to the strategy that you have from day one. If you know you don't have much to work with, you know you're not going to go out and retain a bunch of experts. I mean, it handcuffs you as defense counsel, and it handcuffs us as the carrier as to what our options are. I mean, that's just the reality.
And on these legal malpractice cases, you're talking about whether you're seeing the counterclaims, and I have legal malpractice cases, maybe with a pro se plaintiff and the defense attorneys, they want to sue for their fees, and they want to sue for defamation. Some of these pro se folks will post something on the internet, and the defendant wants it gone. And that counterclaim, the first thing I do is I talk to the insurance company. It may be strategically advantageous for them to fund it, or that they can't allow or disallow it. But down the line, when we settle, if they distance themselves from it, the insured is the one who decides whether to settle that counterclaim.
Yep.
And the plaintiff always says, well, I'm willing to settle, but that counterclaim has to be gone as well. So it becomes a point of discussion and mediation.
For the global resolution.
Right, global resolution,
Right.
mutual resolution.
So how does that affect your communication with the insured when you have a wasting policy in terms of strategy, as Jason?
Well, certainly you want to be more efficient in your communications, number one. But it is something I think that you have to always be addressing with them. And as defense counsel, I believe that you also have to, whether it's monthly, quarterly, you have to routinely be advising your client of your legal expenses, how much has been spent and how much is remaining. So, you know, to the extent you find yourselves in that position, one recommendation I would give you is you copy your client on your invoices to the insurance company, so that they can keep a running tab of what is being spent.
Are there products available for professional liability insurance without the wasting limit type deal?
Yes, there are. And I, for example, at Florida Lawyers Mutual, we do something where you can have a separate limit for your defense. We also build in an extra cushion. That's just something that we chose to do. So there are options out there.
I think, was there a question?
Raise your policy. On this same context of wasting policies, how do you address the issue of bad faith? In other words, if you, as the insurance carrier, direct the litigation and spend sufficient of that money to get what's left below the settlement amount, and now you, maybe the insured is in a predicament because you have essentially used up their indemnity funds in the litigation, and now there's a bad faith situation. You know, there's a settlement within the policy limits that could have been had, you know, and now it's not.
And you're right. That's on us. I mean, that's our job and I agree, by the way, with keeping the insured seeing what the bills are so they know how much is coming down. But that's what we do, is we watch that and we say, okay, we've only got X left. And therefore, that's the thing that makes our job probably the hardest, is managing the decision up front of how hard do we go with the litigation. It's easy when I've got a $10 million limit. That's a no-brainer. It's when I've got the $100,000 limit that you sit there and go, whoa, we really can't do much. But, I mean, what you just described is something that falls on the insurance company. If that situation arises, if you had a chance to settle within the limit and we took the risk of going forward with a defense and then there's not enough left, we're probably going to see a claim after that.
There's going to be a lot of letters going back.
Yeah.
Right, and that is an issue that is at the forefront of every single case where there is a wasting policy.
Right.
And it has to be at the forefront of the insurance company's mind, the defense counsels, and the insureds. It is vital that the three, the triangle or the tripartite, are communicating on a routine basis as to that issue. We're running out of time, and I do want to jump to one particular issue since we have the insurance, Jason from the insurance company here. For the attorneys that are representing insurance company, are there any signs that they can look to that a carrier may be considering bringing a malpractice suit against them?
There are, and I will tell you, when we talked about this panel, I said this is what I call it's the going nuclear option, because it is something that carriers do not do with regularity, and there are a multitude of reasons for that. But getting to the warning signs, the things that I will tell you to look for, if you're defense counsel and these things start happening, you just need to maybe go through your file again and check things out and make sure that everything's in order. Number one is the obvious one. When new management comes into a carrier, it's amazing. Everyone has their own philosophy. Everyone has their own panel of favorites that they like, and they start looking for how they can make that move. So that's a very, very easy thing to spot. When you start seeing cost cutting going on, and it's usually not just with you, but if you hear about it from the adjusters, if they all of a sudden can't travel out for a mediation, or they're being told that they can't go to a conference, or whatever it might be, when you start hearing that there's a lot of cost cutting going on, know that something's going on at the carrier that has them doing some internal soul searching about where they're going, and that can come back to haunt you. Are you getting lots of that kind of hyper scrutiny? Do you have adjusters now asking you about every decision you make, everything that happens? Are they asking you to put things in writing all of a sudden that they didn't before? And I don't want to scare anybody, because God forbid somebody says, hey, can you put that in writing? Oh my God, I'm going to get sued. These are kind of all together. You're trying to assess the situation that's going on. The other thing, of course, is the payment patterns. Are your bills being paid in the pattern that they were before? I mean, some carriers are slower than others, but if all of a sudden a carrier's been paying everything on a quarterly basis without a problem, and now they start dragging their feet a little bit more, and you start having to make phone calls, these are just signs that maybe there's a little bit of a financial problem going on at the company. Maybe they're going to start looking for sources of money. And then the obvious one, of course, is do they bring in new outside counsel? Do they have to say, hey, we're going to move something over, we want to move it over to somebody we know? Because nobody likes taking over a file from somebody else. Mm-hmm. And when they do, they immediately start looking for all the things that they would have done differently, and they document that. It doesn't happen a lot, but when it does, the ramifications are huge on both sides, by the way. When a carrier decides to sue its own counsel for malpractice, it's severing a relationship, and that relationship might be pretty broad. I mean, I used to run a claims department that did nationwide claims. So if we were going to sue one of our counsel, I might have 500 cases with them throughout the country, and there's an impact for other sister companies who use that same firm. So the fallout's huge, but when the decision's made, it gets real ugly real fast.
Jason, just one question on that. I know we're running out of time, but does that trigger some sort of reporting issue when you go through that list? What's your philosophy on that for defense counsel?
Well, meaning that if they start, if you start seeing these things happening, all I can tell you is I would go back and look and make sure that, is there anything that maybe you got a little casual with that you want to make sure you can tighten up? Start looking at your cases. Was there something that precipitated this? And look, there are going to be times when just a case goes bad, and that might be all it takes to set off the war. But I'm talking more about kind of when there's a larger, broader change going on at a carrier, that's when you tend to see those types of things come out. And it's because somebody's trying to either make a name or within the company, or they want to try to carve back some money.
Is there a question? Go ahead.
Do the insurance companies require that defense counsel have their own malpractice insurance?
They do, and that's another warning sign. That was my number one here. I'm glad you brought that up. It's when they start asking you to carry higher limits. It's an interesting conversation to have with somebody, because why do you need me to have higher limits? And so that is, first of all, every carrier does, because, by the way, you are representing the client, and so if there's going to be a problem between the customer and the carrier and the counsel, we're all going to be involved in this. But when they start asking you to increase their limits, that was my number one warning sign.
Right. Any other questions?
I have a question. What's the interaction between the insurance company looking to the outside counsel and finding faults or flaws, but the council's saying, well, hey, I'm serving my client, you're not my client. How does that work?
It's state by state. Some states were allowed to stand in the shoes, other ones were not. And then that's a great point. Because technically, you're right, we're not the client.
Just not talking as a Hartford employee, but as a former panel attorney. What I saw and what I've heard from other people who have run into malpractice problems, it's usually because you didn't document things well that you can't get out of hot water. If your files are a mess or you're playing fast and loose, but you're a really talented lawyer, so you've never really been worried about it before, it'll be that one case that you didn't document anything, or you thought you had put things in the file that aren't there, and the insurance companies, they're like, well, we just got hit for all this money over policy limits, and we can point to you as not having your file up to date, and we can point out flaws. So they'll come after you for that. It doesn't matter who's in charge. I think it's, unless you have some really long-term goodwill with that insurance company, you're probably going to have a problem.
And most likely it's going to happen more in a first-party situation where you're my coverage counsel and you blew tendering a limit or something like that.
And
Murphy's Law.
and then the other area is where you find yourself as counsel sort of toting the line between representing the insured and representing the insurance company. For some firms or for some attorneys, there are cases where you're representing the insurance company, and then there are cases where you're representing the insured. So if you are an attorney who has that kind of practice, it is extremely important that up front, day one, you clarify with the insurance company, am I representing you or am I representing your insured? And you document that in writing so that there can never be a question as to who your loyalty is on a particular assignment.
Very good.
And
A lot of times the insurance companies don't even know.
Right, yeah, absolutely. And other times they don't know that there's a distinction. It's, believe it or not. And they want you representing both. Right, exactly.
Well, excellent. It was very-
Any other questions?
Thanks for your dynamic